Now, in about 3 minutes, let me turn quickly to the massive subject of healthcare and the individual mandate. As I'm sure everybody here is aware, part of the massive healthcare bill was a provision of the so-called individual mandate, which said essentially that everybody had to have health insurance, and if you didn't get it within a certain time, you were subject to a penalty. And the reason for this is, apart from other things, the law was mandating that people could not be denied insurance if they had pre-existing conditions. And the only way you could, from an economic standpoint of an insurance company, afford to have to take in people with pre-existing conditions is if you've got a lot of healthy people into the system to help pay for it. Well, here again, the issue has come down to speculating about what Kennedy might vote. One fairly typical comment from a newspaper that is critical of the law and has frequently been critical of Justice Kennedy, the Wall Street Journal, said as follows: "Today's court is now divided more or less evenly between those who think the Constitution means nothing and those who believe it can mean more or less anything. Between those who think the Constitution means something and those who believe it can mean more or less anything they want it to mean. In between these two groups sits Justice Kennedy, who has a record of respect for the Constitution, save for those cases where it might really annoy the New York Times." That is a snide and not particularly original comment about Justice Kennedy. And I will tell you, having thought and read about it a good deal, I think it's baloney. Justice Kennedy has written, I'm sure I can demonstrate, more opinions and voted in more cases in ways that the New York Times doesn't like than the ways in the cases that they happen to approve it. But in some folks' eyes, if you get approved by the New York Times once, that's kind of the kiss of death. Now, we can talk endlessly about the issues of law that are proposed by the health care law, but it really comes down to probably whether or not it is something that is properly regulated under the Commerce Clause of the United States. And in that case, the argument tends to devolve down to whether not buying health insurance is an activity or is it inactivity? And does that matter? And if it does matter, can it be said that not buying insurance is an activity? The argument being is that you're making a conscious decision and you're going to need health care at some point, and you're making a decision not to pay for it. There are no cases that anyone has come up with that really deal with the question of whether there is a significant distinction between activity and inactivity. There are 3 or 4 cases that have some bearing on limits to the Commerce Clause, but none of them directly on point. One of them you may or may not have heard about was a case going back in the 1930s, Wickard against Filbert. Wickard was an Ohio wheat farmer, and he was growing wheat on his farm for his own use, not to sell, but to use on his farm and feed to his chickens and so forth. And under the Agricultural Adjustment Act, he was entitled to have only 11 acres of wheat. And the rebellious fellow went out and planted 23 acres of wheat and had some 200 extra bushels of wheat, for which he was subjected to a penalty of $117.17. And the issue was this fellow had grown wheat in his backyard, right, in his back 40 or 23. Was he affecting interstate commerce? And the court said, well, he was, and therefore it was could be regulated under the Commerce Clause. After Wickard against Filburn, a lot of people assumed, and I recall essentially being taught in law school in the 50s, that Congress could pretty much do what it wanted under the Commerce Clause. There really weren't any limits. Well, back in the 90s in the Rehnquist Court, there were a couple of limitations that came up. One was in a case called Lopez involving a law called the Gun-Free School Zones Act. The federal law that made a crime to carry a gun within so many feet of the school. And the Supreme Court held that might be a perfectly sensible law for a state or a municipality to have, but it really did not involve commerce or federal activity. That carrying a gun into a school zone was not a commercial activity. It didn't have anything to do with commerce. So that law was unconstitutional. Similar case, a couple of years later, involving the Violence Against Women Act, and the court similarly held that someone could not be prosecuted under the federal law for committing a violent act against a woman because that was not, again, a commercial activity. Now, a lot of people thought that might herald a whole wave of cases invalidating statutes under the Commerce Clause. That did not happen. And in one case, seem to go back a little bit, that was one in which Justice Kennedy and Justice Scalia were part of the majority of the court, joining Justices Stevens, Ginsburg, and Breyer, holding that the Federal Controlled Substances Act, drug law, could ban the home cultivation of marijuana for medical purposes as authorized by law here in California. There were vigorous dissents by, among others, Justice O'Connor, who was saying this is quite different from Mr. Wickard, who was harvesting acres and acres of wheat, and here we're talking about people with little herb gardens. And so the impact in relation to commerce was much more tenuous. How the court will rule, anyone's guess. There's one cautionary comment by Kennedy, although he joined the opinion in Lopez. He did say along the way, the history of the judicial struggle to interpret the Commerce Clause during the transition from the economic system the founders knew to the single national market still emergent in our own era, counsels great restraint before the court determines that the clause is insufficient to support an exercise of the national power. I'll stop there, and I think I've run out of time.
Well, if there's a question or two, let's in the back.
Last week, the Wall Street Journal had an article on Justice Clarence Thomas regarding the fact that he's been silent for the last 5 years and never said anything during an open court session. Do you have any reason for that? Anything that's one, or maybe he has nothing to say?
No, I think it's just a matter of personal style. In fact, I read just in the last few days someone commenting that in the days before Justice Scalia joined the court was much less active in its questioning than it is now. It is not to say they were as silent as Justice Thomas, but the questions were much fewer. In fact, I previously once read an anecdote of Scalia's first day on the court when he plunged right in and was asking questions left and right. And one of the justices turned to the other justice and said, "Do you think he knows we're here?" My own feeling is that it's not a great loss for him not to do that. I think it's a question of what he finds useful or not useful. I think it's clear that many of the justices use the questions not to actually get information, but to make a point with their other justices. They're trying to draw out the counsel in giving an answer that they think will help persuade a justice that they believe does not see things quite as they do. So I think it would be a shame if we had 9 justices like that, but I think having one or even 2, does not detract from the process.
One more question over here.
Thank you. Both about Justice Thomas. First, about Thomas not asking questions. I think he doesn't ask questions because he's already made up his mind and nothing can change his opinion before he walks into the courtroom. I think he's just dead, he's got a fixed agenda and he has made up his mind. But that's not my question. That's a comment. My question is, I have heard, and I'm assuming it's true, that his wife is employed by either a lobby firm or a firm that is working to overcome the healthcare law. And my question is, shouldn't he recuse himself from making a decision if his wife is in fact doing that?
Well, refusal of Supreme Court justices is a very tricky business. First of all, it's a long-standing and, as far as I know, unbroken tradition that justices make up their own mind as to whether or not they should recuse themselves. If there is sufficient press devoted to this, it could make things uncomfortable enough that he might consider that, but I would tend to be surprised. I would also say that while I think it's a legitimate matter of concern, it is a matter of concern at the level of appearance of conflict, in terms of being an actual conflict, in terms of Thomas actually being influenced. I don't think that's a factor at all. So, in saying that, I don't say that the interference is not grounds for concern, but in terms of an actual factual conflict, I don't believe it exists.
Thank you.
Well, thank you.